A very warm welcome. You are tuned to 3T TV, Thika's #1 online news channel, where as always, we are telling the Thika story as it is. My name is Juliet Modoni, and today I am in the company of a lawyer who is going to expound on a few issues that you and I are probably struggling with, and we do not know how to go about it. These issues may seem mundane, but for sure we struggle with them each and every day, and we want to talk to the professionals so that they can guide us on how to go about it. And we hope that by the end of this segment, you will have learned a thing or two, and if you haven't subscribed, you will subscribe. So let the segment begin. How are you doing?
Very well.
Thank you very much for finding time to have this conversation with us. Kindly introduce yourself, let us know who you are and what it is that you do.
Thank you. My name is Peter Njage. I'm an advocate of the High Court of Kenya. I practice in the name and style of Mwenda Njage and Company Advocates. I'm situated at Seattle City Mall, Kiambu Road, Runda, Block A, 3rd floor, and I'm a practitioner of law. Thank you.
Thank you very much. We will try and use simple English, not jargons.
Very good.
Yeah. Now, we've been going through a pandemic over the last 2 or so years, and we've seen very many people who've lost their jobs and their livelihoods, and they've not been able to pay rent, be it offices or homes. And there are many people who have struggled with rent, and they do not know how to go about in case there's a dispute between you and your landlord. I would like us to begin by explaining what does the tenancy and landlord relationship entail.
Thank you, Juliet. The relationship between a landlord and a tenant, I treat it like a marriage. It is a union that is meant to last for the times of good and for the time of bad times. So it's upon the two parties to understand and to find a way on how they would live harmoniously. By ways of definition, maybe a landlord is somebody who has leased you the premises with or without a lease, and I'll explain the two types of tenancy that we have, and the tenant is a person in occupation. We also could have another kind of a tenant who, upon leasing the property from the landlord, goes ahead and sublets that property to other tenants, so that he mutates now from being a tenant to what could be described as a sub-landlord. So that the landlord now, he owns the premises, he's supposed to enjoy the rent, and the tenant is supposed to enjoy the premises. And of course, there are rights which we know for each individual should have. So that's basically the upshot of the relationship between a landlord and a tenant.
You had spoken about the different types of tenancy. Please take us through that as well.
Very well. The tenancy can be broadly categorized into two spheres. There is a tenancy in terms of a home, whereby it's a premises which you are living, which you could safely say it's governed by the rent restriction, a dwelling home. Yeah. There is also a tenancy whereby the premises or the area that you've leased is for purposes of a business, which could be described as a business premises. And in a business premises, we could have a controlled tenancy, which most of our people subscribe to, or an uncontrolled tenancy. A controlled tenancy is whereby you are in a premises which you're doing business, and you have a lease of below 5 years. So that now, if the landlord is to terminate that tenancy, he cannot terminate it without reference to the Business Premises Rent Tribunal. The other one, the test applicable, because I want to give you five tests that can test a controlled tenancy, is whereby the lease is over 5 years, but when the 5 years lapsed, the landlord went ahead and still continued to take your rent. Okay. So that now you became also a controlled tenant. The other one is whereby the lease is of 5 years, 1 month, 5 years, 3 months, but it provides for a termination clause. Okay. Like you could say, either party can give another person a notice of 1 month, you become also a controlled tenant. The other one is whereby the lease expressly says that my relationship with Juliet, who is my landlady, is a controlled tenant. Basically, for the purposes of the viewer, what a controlled tenant simply means is that you cannot be distressed or you cannot be evicted without leave, or in simple language, without permission from the courts. And the courts in this case means a tribunal. So if you're a control tenant, the tribunal governs your relationship. If you're a control tenant, maybe you have a lease now of 5 years, there is no termination clause, and the lease does not provide for control tenancy, then you have to file a case in the normal courts, like Environment Land Court and the High Court. But if it's below 5 years, then the tribunal is for you. And there are some schools of thought that maybe the tribunal is pro-tenant because it's supposed to check the imbalance, because the relationship between a landlord and a tenant may be unequal, so that now the tribunal is supposed to uplift the person who is disadvantaged, in this case usually the tenant, for you to have a level playing field. So those are the issues that can make you now go and approach the court for purpose of protection. Like, for example, the landlord is trying to throw you out and you're in a business premises and you're a control tenant, and the landlord has not informed the court through a reference. A reference simply means you have not informed the court through a file, because you should file your notice through the court. But in most circumstances, you find that in a business premises, you're being told you're being given 2 months to vacate.
Sure.
And that's unlawful, because you should have obtained permission or leave from the courts, from the premises. And that's the beauty of our law, because it's supposed to check those kind of inequalities to ensure at least there is a level of playing field between the two players.
Fair enough. That's quite a lot to digest. You've mentioned something that most of us don't know about, a tribunal, but we will get to it later on. I'd like you to break down for us, what are the obligations of a landlord? And also, what are the obligations of a tenant?
Maybe the first obligation, because everybody wants to be a landlord, is that you have an obligation and a right maybe to collect rent. And that's something that is very appealing to most of us, that you want to be a landlord.
Yes.
Or to be what we say, you kuishi kwako, or you want to be a landlord as a source of income. So one of the things is that as a landlord, you are able to obtain the rent from the premises. You are also obligated to give care and control of that premises in terms of normal, reasonable wear and tear. The third ingredient, by virtue of you, the landlord, you can have also the right to have a reasonable access to the premises.
Okay.
What I mean is that even if you've leased the premises to a tenant and you want maybe to come and assess how the property is, you cannot be barricaded from you accessing it, but you should come in godly hours. You cannot come, usually we talk about business hours,
sure.
8 to 5, and you must give reasonable notice to the tenant and tell them, maybe I want to check the roof, whether it's leaking, to check the issues to do with the drainage. That's part of your duty. Importantly for the tenant, upon you having occupancy means possession. You can have put a stool, you can have put a desk, but the fact that you have even locked a premises and there's nothing there, and maybe the landlord cannot access the premises, you have the right to be called the occupant of that premises. You have now the right to enjoy peace and quiet of that premises and to do the business that you're supposed to do. And if the lease does not provide for alteration of the business, you can change. If the lease maybe was silent in terms of the nature of business you could do, because maybe you could have written the lease is for purpose of electronics, then you discover maybe if I start a milk bar, it could do much better. So you can change that without permission from the landlord if the lease so allowed. But if you have to get prior permission, then you have to inform that. So essentially, you are supposed to enjoy the premises during the tenancy and the continuation of the period.
You're using the word lease very often, and I think it's a strange word. Many of us live in places where we do not have a written agreement or a lease. Ulikutana na mwenye nyumba, wewe unatafuta nyumba, anatafuta tenant. Oh yeah, you can come in, you negotiated a certain amount and you've been paying without any lease or any written document. What danger does that pose?
Very well. Maybe the term lease should not scare the viewer. The lease simply means an agreement, or what you could call a pact, or a treaty, or a covenant. All those are synonyms. What is important is that a lease or an agreement need not to be reduced into writing. The moment that I've agreed, you are taking these premises, I'll be paying X amount of money, we have what in law the meeting of the minds, meaning you have already had an agreement, even if it's oral. So this thing of saying tuandikiane, it's not necessarily proof.
Okay.
It's enough. The only thing that should be reduced into writing according to the law is an agreement for land.
Okay.
But even any other agreement can also be oral, provided it is verifiable.
Okay.
So if you don't have an oral, if it's an oral agreement that governs your relationship, you also become a controlled tenant. So that now, if you had agreed, I'm going to pay X for this period, the lease now is supposed to govern relationship. It is basically like a compass or a roadmap on the do's and don'ts between the two of you, so that you're able to have a harmonious relationship.
Very well. Thank you for clarifying on that, you don't necessarily have to have it in writing. Now, you've mentioned that as a landlord, the landlord has the right to get into the premises and probably do an inspection. What if in the event that this landlord does not meet the obligations of maintaining the premises? What is the procedure that should be used? And does the tenant have a right to demand for such services?
Excellent. That's a very relevant question, because some landlords are known to be allergic to notices in terms of improvements,
Yes.
but they seem to have a very good memory when they're demanding the rent.
Sure.
So the balance should be checked into, and the law envisages such a scenario. If your roof is sinking, or your plumbing works are wanting, or electrical defects are there, which are not cost, the causation is not the tenant, but maybe reasonable entail because of period, you are supposed to notify the landlord in writing and tell them, look, these areas are defective, can you rectify, can you cure these defects? Two things are likely to happen. He can send his own assessor to come and look into it, and they can change and remedy that error. The second one, they may ignore, but because you don't live in the premises, you go ahead and repair. Since you already given them notice, you could ask for restitution, saying, my rent is 10,000, but I repaired 2,000, and I'd given you notice. These are my receipts, so I'm going to less from the rent. Why I'm talking about that route? You should be put back to the situation you enjoyed before, because it's not your duty to rectify major defects. But if your child maybe breaks a window, which is your own making, then it behooves the tenant to make good the payment.
Awesome. Now, vice versa. The elephant in the room. In the case a tenant defaults probably paying rent or damages property and does not want to own up and, pay, what procedure should the landlord use to claim money? Because we've seen landlords harassing people and we don't know what procedure should be used.
Very well. I'm of the very considered view that even levying interest is void.
Okay.
Because you're not a bank
Sure.
or a financial institution for you to levy interest on rent. There are remedies, or there are ways on how you can make good your debt. There is a Distress of Rent Act, which provides you in default of maybe a period exceeding a month, you can, with or without a court order, send an auctioneer to distress rent on your own behalf. What that means, that auctioneer comes to the premises and does something called an inventory, and says, I found this laptop, I found this phone, this desk, and it gives what we call an estimated value. They are not obligated at that time to do a valuation report. Then after that, they give you 14 days notice to make good the debt under the act, or a longer period if the agreement had provided for a longer period in terms of a distress. During the intervening period of 14 days, you could have found money and you can make good the debt.
Sure.
If you haven't found money, you rush to the tribunal and you could argue that, look, I'm willing to pay, but there is something called hardship because of this pandemic of COVID. Nobody had foreseen it. But I'm able to liquidate my debt, but I'm asking that in as much as I'm supposed to pay this is my source of livelihood, or the auctioneer has distressed your tools of trade. Because maybe to the listener, the auctioneer has no right to distress your tools of trade. If you are a tailor and your main tool is a sewing machine, he cannot come and carry your sewing machine. He should look for other things. But what we have, because of lack of maybe information or knowledge, he comes and takes even your tools. Because how will you earn a livelihood if he's taking your tools? He's supposed to distress other things other than your primary tools of trade. Secondly, we are dealing with a court of law, not a court of mercy. So you cannot go and say you want time, but you should be given a justifiable period. But the tribunal looks and says, look, you owe 3 months rent. Can you at least defray a month? Or you give a payment plan. You could also go and say the rent arrears is disputed.
Sure.
You could also go and say that, look, I'm willing to pay, but he's also asking for interest. And I'm feeling this interest is punitive. You could also say I'm willing to pay, but he's not only requiring for rent arrears and interest, but also they're asking for auctioneer's charges. So that now, those are the things that arise. If indeed maybe like in a big premises, like an industrial setup or a commercial enterprise, and they have distressed your items, because most people have really suffered with this kind of pandemic, you could go and seek leave to have those goods valued. Because usually most people after distress, they live in shame, or they don't talk, or they don't share, or they hide their head under the sand. But you could say, look, I have no problem to pay, but I think the things you wrote here, you are not qualified as a valuer. You have no business telling me this biro is worth 10 shillings, and you have no schooling in the school of valuation. So you ask for a valuer, they value the premises, the goods they have distressed, they sell through auction, they may end up even giving you more. But now most people keep quiet. So those are the upshot of the matter, and it's a very broad area that somebody should, when such kind of an issue happens, it's good to get good legal representation and advice.
Talking of auctioneers, it's a rather wide topic, and you know it's a sore in the thumb for most people. We've seen advertisements in the newspaper, 2 pages, 3 pages of items being auctioned. Please tell us, like myself as a tenant, should the landlord break into my house and pick my stuff? Is the landlord allowed to put another padlock? How should that go? At what point should auctioneers come? And what is the process that should be used? Should my stuff be broken or vandalized? Should I be harassed? What is the process?
Thank you, Juliet. The answer to that question is a resounding no. The landlord, neither the landlord nor the auctioneer has any right or in law to enter into your premises. If you lock your premises and you're in arrears, I must say that being in arrears is not a criminal offense.
Sure.
And nobody enters a premises not to pay. But these are events that happen. That's why people have ways to rectify it. So that if indeed you have fallen into arrears, and maybe you become an absentee tenant, there are some tenants also who may be mischievous. They may run away. So that now as a landlord, you are at a loss. You can neither access the premises or enjoy the rent.
Sure.
The law is very clear. Go and seek for a breaking order, because it should be a supervised breaking in with the local OCS, or you can send his officers plus the auctioneer, who now come and break and say, look, we've taken these things, and they do an itemization. It should be signed by the landlord or the landlord representative, or the tenant or the tenant representative if they are there. If they are absent, it can be verified by an officer of court or of the law. So that now, if now you come and claim tomorrow, I had maybe 1 million shillings in my safe and you broke into my premises, they would say, no, look, that's not the truth. So the checks and balances here are meant also to safeguard that also as a landlord, you also have a right to enjoy the fruits of your labor. You also have the rights to enjoy the fruits of your investment, because you could have invested, but then the tenant is not within the vicinity. He's neither picking your calls, nor is he aware about his whereabouts. So the reasonable thing to do is for you to seek permission from the court through a court order, and you inform the court, this person, I have leased to him the premises, he's gone away, can I get a breaking order? The notion of removing a door, putting an extra padlock, it borders also on elements of criminal culpability, like malicious damage to property. Because the moment now you come and cut my padlock, it may seem something very small, but that padlock is my padlock as my tenant. It's my property, and you have destroyed my property. You have no difference with somebody who has destroyed a fence of somebody's real estate or property. So the right thing to do is you seek that kind of leave. And at the point of departure, because maybe the relationship may become very sore, or maybe the tenancy lapses, or maybe somebody cannot sustain the rent anymore, is that's why the deposit it should be there, because you can now be told to put back the premises in the position it was, or you can agree, because the law promotes what you call alternative dispute resolution. You could sit and agree with your landlord and tell them, look, I'm not able to sustain these premises. Can you allow me to utilize my deposit as part payment of my rent? But most tenants also think it's a matter of right. It's not as a matter of right. It's supposed to be assessed. Maybe if there's any breakages, you make good the premises. If they're not, they cover the arrears. So maybe to the listener is that in as much as there may be these very strong positions you may be having, it helps to employ mediation. You can negotiate. You could also seek what you could call conciliation, so that you're able to have a more harmonious relationship. Even issues that arise like rent reduction, because there are some instances whereby you could see, like in malls, you are told we are going to shelve maybe a few periods, few months, to whatever, to caution the tenants. It's not a matter of a right, it's a matter of the relationship between the two of you. But maybe before you move to the next phase, if you can kindly allow me,
Please.
The law also allows for rent assessment.
Okay.
That's something also most tenants don't know. If you are a controlled tenant, notwithstanding the agreement you have, if you feel that your rent is excessive, or is exorbitant, or has is oppressive, because there's some agreements which can also be oppressive, you should file a reference to the tribunal, and you tell the court, look, I'm paying this kind of rent. Yes, I may be having a lease, but I'm thinking the law provides that you have the power to request the court for purposes of rent assessment. So those are avenues that maybe a tenant can explore.
Wow, that's quite a lot. And I don't want us to get to the tribunal yet, but you've mentioned something very interesting. Deposits. Depo yangu.
Depo yangu.
Hey. Please tell us, hii deposit, kazi yake huwa ni nini haswa? When should it come into cushion? Because I think it should cushion me probably when I can't pay rent. Enlighten us a little bit on that.
Deposit goes back to what I had said to be about interest, because also maybe when I'm representing tenants, because they're the ones who come aggrieved most of the time,
Yes.
I also put to court that this tenant should not be punished, because even his deposit has not been earning interest. So
Sure.
there should be reciprocity.
Yes.
If you are demanding interest from my rent, then also you should have put my deposit in an interest earning account. But the question about deposit, it is not meant to be part payment of rent. Deposit is simply meant to as security of cost.
Okay.
In an instance whereby you come to my premises and you vandalize it, so that by the time you're departing, I may be forced to dig into my pocket to cure those defects.
Yeah.
The issue also that arises whereby you have also come to the premises and maybe have distressed you because you have not been able to pay. But even if I sell the goods that you have, I may not be able to recover my rent. So that now that can be used to be offsetting. Maybe the recent past, maybe before COVID, we used to have this, people used to call Goodwill. And Goodwill, maybe that's something that can also be treated like a deposit, because questions arise, is Goodwill transferable? You have opened a small shop to sell maybe phone accessories. You've paid maybe 100,000, a million shillings for the Goodwill. You want to depart. You're not able maybe to pay the rent.
Allow me to cut you short. Probably for the sake of somebody who doesn't understand Goodwill. What is Goodwill?
Goodwill is basically a term that has been used by commercial men and women to, it's over and above the rent.
Okay.
Maybe anything that you pay above the rent and anything you pay above the deposit for purposes towards the benefit of the other person. But Goodwill has been abused, because you know Goodwill should be paid for an ongoing enterprise. So that I've been having this shop, it has been running. I'm not able maybe to continue with my tenancy.
Okay.
So I approach my landlord. I tell the landlord, look, my lease is for 5 years, I've run it for 2 years. Can you allow me for the remainder of my term, because you should get consent from the landlord, unless the lease provide otherwise. Can you allow Juliet now to come and inherit my business for the 3 years?
Okay.
Because I'm not able maybe to sustain, or I'm relocating to a different town or a different city. So that now between now the former tenant and the new tenant, we agree, since you're going to inherit my business and my stock and my customers, can you pay goodwill of $1 million shillings? And you say, I'll pay. Why the abuse comes is whereby you find an instance whereby the premises is new, it has no former tenants, it's a new enterprise, and the goodwill is being demanded by the landlord. So the question arises, what goodwill are you transferring to me? Because goodwill is basically for an ongoing concern. But the law also provides for freedom of contract. But if you're a vigilant tenant, those are the questions you should raise, and you could find that actually you should not pay that goodwill. Because now the question also arises, after you've paid your goodwill to the landlord, at the point of departure, is that goodwill refundable? And most likely you'll be told it's an emphatic no. They hardly return that goodwill. So that now you've gone, because it's a new shop or a new maybe stalls that have come up, the landlord tells you, my rent is 10,000, 3 months rent, 3 months deposit, that's 60, and goodwill of 500,000. So the question arises, since deposit is refundable, is also the landlord obliged to refund the goodwill? And most likely they don't. So I would treat that as more, there's no difference between that and extortion.
We strike a balance between the rights of the tenant and the rights of the landlord, because they need to coexist. They actually need to coexist. Now, I'd like us now to talk about the rent tribunal. You've mentioned it quite a lot in your explanations. What is the rent tribunal? Where is it found? And how can it help the landlord and also the tenant?
Thank you. Maybe there are two kinds of tribunals.
Okay.
There is what we call the Business Premises Rent Tribunal, fondly known as BPRT. It's in Nairobi, headquarters, VPAC Towers, 14th floor. That's where they are situated. But it is a circuit court, meaning it is rotational court. They can be sitting in Mombasa, Nakuru, they go around. But now they have increased their personnel. Before, used to have one chairman. Now I can see they're sitting more like a tribunal. So they're able to dispense with most matters, because before the chairman would have to travel around. So this one governs business premises, as the name suggests. And you have to be a control tenant, as pursuant to what I had explained before.
Yes.
Then you have the rent restriction tribunal, is for the dwelling houses. And it provides for very little rent for you to go to court, but the circumstances, notwithstanding the rent which is very low, prescribed in the Act, you could argue that that rent has not been valued for you to have audience with the court. So it is meant maybe when there is disputes, because a dispute includes a grievance, it includes a difference, or includes a claim, how you can go and ventilate your issue, and that is the tribunal. It is a business tribunal, and that's where you go if you're a control tenant. If you're a business, and maybe you're not a control tenant, maybe your lease is 6 years, or a long-term lease of 10 years, then you should go to High Court in the division known as Environment Land Court, because a landlord-tenant relationship is also, there has to be some land somewhere.
Yes.
For you to be that tenant. That's why you have the land, then the lord. So that's why you go to the Environment Land Court, and that's why it's supposed to hear those issues. Maybe what I should maybe say is that the landlord also is protected through the Act. If the tenant is not paying, you can file a reference and you give him a month notice. Or maybe when you want to change the premises for your own use, or maybe you want to change the premises for purposes of maybe feel that now I can as well do some stalls, but that should be a justifiable reason. So file a reference. It will save you much time and much cost, instead of you doing things procedurally, because if the tenant goes there first, he's going to get what you call an injunctive order, and he will stop you. But you can as well go there as a landlord and file the proper way. The cost is very minimum, peppercorn, very low. And you tell them, look, I filed my reference, put your house in order, I want my premises. Maybe because of the history you've had with the tenant, or maybe it's because of a genuine reason that maybe you want to dispose the property. and maybe the person you're selling to wants vacant possession. So he's saying, I can buy your property, but I don't want to inherit your tenants. So the court will look, it's a case-to-case basis, there has to be merits. But you cannot rush there to just to file a reference to throw to the tenant purely because your personal differences. Maybe you don't like how he looks, or maybe you discovered something that, or maybe he's getting more business, or maybe you are competing businesses, because there may be an instance whereby the landlord and the tenant, they're in the same enterprise or in the same commercial activity, the same premises. So it's not cast in stone. It's how you ventilate your case. It's how you project your matter.
Talking of competing in businesses, we have seen some tenants who you've rented a place, then now you sublet it to somebody else. What does the law say about that? Because it's a bit of murky waters there.
I get what you mean. Maybe what you have in mind is like somebody has taken a hall and somebody into small stalls.
Yes.
That one can be either sanctioned by the landlord, but most often it is not sanctioned. Somebody has come and taken maybe a whole wing or a whole hall, then done some subdivisions. And maybe the landlord discovers, look, you're paying me 100,000, but you have 10 stalls, each charging 20,000, so you're making 200,000, so I can as well become the landlord to these subtenants.
Sure.
That happens a lot. And I'll tell you a practical example which I was able to handle. And I was representing the subtenants who now, the main landlord had written to them telling them, you should either vacate or you'll be paying me. You forget about my landlord, my tenant rather. And we got an order. And the question there that was before, there was no contractual obligation between the person who is on the ground, who is the tenant, with the owners of the building. Because there is what we call latches or delay. If today, Juliet, you sleep on your rights, you know this person has subletted, and you keep quiet for 3-4 years. Then you wake up from your sleep one day and you discover, oh look, I can as well be getting much more rent, because some of these rents, the main tenant is being very minimal compared to whatever he's getting. So what should happen in that instance? The subtenant is also recognized in law. The fact that he's paying rent and there is proof of payment, there can be an issuance of receipt, there can be through M-Pesa. He is protected and he cannot be evicted unprocedurally without the reference. So everybody is covered, and the law envisages such a scenario because a subtenant is also a tenant.
Sure.
Yes, and he should enjoy the premises as and when the tenancy subsists. What would happen if maybe the tenant has subdivided without consent or the leave or permission from the landlord, and the landlord is vigilant? He can go and say, look, I'm giving you 1 month notice to vacate, because that's a fundamental breach of the agreement, because the agreement had not provided for a scenario whereby you should sublet. So all those things are looked at on their own meritocracy.
Wow, that's quite a lot to digest. And that is where you as a lawyer comes in. And there's a lot we can talk about tenants and landlords. I'd like us, maybe as we come to a conclusion, you've spoken about these middlemen, and we see agents on the ground. Agents who sometimes bring sanity, but more often than not bring a lot of chaos, because we see they harass us every now and then. Where do agents come in case of anything? As a tenant, am I protected from these agents?
That's a very beautiful question, if I may say that, because agents, they are loved and loathed in equal measure because of maybe their militant way to correct rent. So they may be, on one hand, good for the landlord, because they may be good in collecting rent, but also maybe not very good to the tenant. What I need maybe to say is that an agency business is a regulated business, and most of these agents you see operating, they are not licensed, because as an agent you are licensed by what we call the Estate Agents Act. You see, like even when people are talking about broker, if I may use that word.
Sure.
Ameuza shamba, you sold this land, he wants maybe 5% commission or 3%. Those agents who do that through brokerage, they are engaging in a business which is a regulated business. It's actually like engaging in a practice which is a governed business, but you have no license. So the first question should be, is that agent licensed? Because most of them, they are not, unfortunately. The beauty of an agent is fourfold. I'll give you 4 scenarios. One is that they also help in the ease of communication between the landlord and the tenant. Because if you have a sober agent, it may also give you a relationship time more to last. Because he may be the sieve, maybe to curtail maybe toxic relationship. The other thing is also, may also hasten repairs or maybe care and control, especially like to those people who may be living in apartments because of the numbers involved. The landlord may not, maybe practically, be able to handle each individual. And the third thing is that the agent also happens, and these things happen very oftenly. You've paid the agent, but maybe the rent never reached the landlord.
Sure.
So maybe the landlord tells you, look, I never received your rent, you have to pay twice. But I must say that the acts of an agent bind the principal. Meaning, if this agent was in active employment at the point of collection of that rent, then by virtue that he collected that rent, the landlord is duty bound to treat that as part of payment of rent. Unless and until he notifies the tenants and tells them, look, person X was my agent, but he has his employment from the 1st of February. So don't deal with him. So if you go ahead and you pay, so that's your own shauri. The last item happens whereby the agency also has a duty to issue you with a receipt. Because things happen whereby sometimes you're told you pay the landlord, but is the agent managing. Those things happen. So you wonder who will give you the slip. So who should you give the slip? Is it the person you are paying or the person managing? So some of them use that kind of avenue to maybe escape or to defeat the end of justice. Yes. But if you are paying, the recipient of the funds is bound to give you the receipt for ease of reference. Yes. So that's what I can say about the agency.
Thank you very much. You've totally enlightened us on a lot, and we will be seeking your counsel on many other issues. Now, as we conclude, there's somebody who is watching and would like to know how they can find you, probably a phone number through which they can reach you and where you're located as well.
First of all, I wish to thank the fraternity for 3T TV for finding time to grace my humble abode. I'm very grateful for your visit to these chambers. We practice at Seattle City Mall, Kiambu Road, Block A, 3rd floor in Runda. You can get me through the office line of 0718 810 300. 0718 810 300, and I'm available on short call basis. You don't need an appointment. This is your home. Thank you.
Thank you very much, Peter. So, ladies and gentlemen, that was Peter, who is a professional in matters mediation. Remember, you are watching 3T TV, Thika's #1 online news channel, where as always, we are telling the Thika story as it is. And as I keep telling you, this year we are doing things differently. It will not be business as usual. We have to do things professionally. So until next time, my name is Juliet Mudhoni. Take care.